Okay, so let's go right into our next session. Let me do introduction, but I'm making our next speaker, Kevin Buckley. He has presentation capability, so he can load up his presentation. So the next session is going to focus on the intersection of AI and intellectual property. Speaking on this issue, very pleased to introduce Kevin Buckley, who is a founder and senior U.S. patent attorney at Torrey Pines Law Group. He's an accomplished patent and transaction attorney. He has more than 20 years of experience as a biopharma and digital health executive and lawyer. He is currently an advisor to Aquilas Ventures, a medtech venture capital firm, and is also a medtech accelerator advisor at UCSD's University of California, San Diego's Institute for Global Entrepreneurs. Prior to becoming an attorney, he was a biochemist studying immuno-oncology, RNA-delivered antiviral therapeutics, and bioinformatics systems. Let's turn the session over to Kevin Buckley from Torrey Pines Law Group to talk to us about the intersection of intellectual property law and AI.
Great. Thank you, David. And so can you see a bright orange screen that I'm presenting? Excellent. Okay. And I'm assuming everybody can hear me. So thank you for using so many big words. I have that on my biography, and you guys, it's just mostly puffery, but it does describe what I've done in the past. So what I thought, being part of this, great group of looking at the valuation of AI technologies related to IP, which is a good basis for determining the value of certain AI technologies. I really need to do what I do on a daily basis, which is translate between the technical, legal, and business parts of AI. And I think this will provide a pretty strong basis for kind of the fundamentals, but also looking at ways to value certain IP. So, oh boy. All right. I am trying to get to the, oh, there it is. Okay. So, all right, this is just a bunch of, I don't know, extra stuff you don't need to look at. But the coolest thing, guys, Chambers and Partners, which is one of the really prominent law firm ranking organizations, they called me up a few months ago and selected my firm as one of the best small to mid-size IP shops in California. So Torrey Pines Law Group is tomorrow going to be listed on their spotlight as one of the best, IP shops in California, and it's largely based on what we do with AI. So pretty cool stuff. And the way that most clients and the way that we look at handling the entire workflow for artificial intelligence, this is a really simplified version of what AI is in my mind and most of our clients' minds. But we always look at things to protect in terms of inputs, the engine, which is the traditional software, which we call AI, and then the outputs, which are hopefully in protecting IP. Hopefully these things are novel, non-obvious, and something that we could take for a patent, wrap a trademark application around it, certainly protect the underlying copyrights, things like that. The most important part here is these data sources. And, Jonathan looked at, this question earlier about, data, where it resides, what type of data it is. This is probably one of the most controversial aspects of artificial intelligence, where we get this data, where we put it, Romania versus the United States, what type of data it is, personally identifiable information that is subject to GDPR in Europe, CCPA in California, HIPAA, if it has any protected health information, things like that. You guys, it's the most valuable part of the AI workflow, but also certainly the toughest to get your head around when you're trying to protect it using intellectual property laws and regulations. So if we just look at what these inputs are, what the engines are, what the outputs are. Typically, the inputs that we're talking about, it's data, but some of the data can be proprietary. This could be something generated in-house at a small company, generated at IBM, generated at Apple, generated at Amazon. These could be proprietary data sets that are then utilized by the AI engine to ultimately provide what is hopefully a novel and valuable output, which is what I call a final report. And other times, the data sources are open source. These things are images of cats and blueberry muffins, and do they look similar? These are things that you can find on Google. The combination of the proprietary and open source data sets is usually where our clients go to generate, utilizing AI, some final prediction, some final ranking or score, which is utilized in the example we utilized before, looking at an X-ray and determining if breast cancer is in an X-ray. By the way, I patented that. So that was a fortuitous example, but it's a great example for this workflow. So the X-ray or a set of X-rays would be the input. The artificial intelligence engine, the software that is trained to look at these things as they come in, whether it's from a hospital system or something that an individual client would upload and down to Amazon Web Services to determine if they have a predictive score of having breast cancer. So that's an excellent example of what these workflows entail. So the way that the proprietary data, the input, is used, sometimes the individual data set or the combination of data sets is not enough. So either in-house at IBM or Meta or Google, you have to generate what would be called a synthetic. So this is kind of a make-believe assistance to the data so that additional data can be utilized to train this engine. All right, these engines, you guys, these again can be proprietary or they can be open source. And here's the danger of both proprietary and open source utilization within these workflows. Proprietary data, proprietary engines, these are AI software algorithms that could be developed in-house. Great. Copyrighted, protectable. These are trade secrets and know-how usually. When it comes to open source, though, this is where we really get into problems. And this really comes down to value as well. So a lot of these valuation experts on this call, when you're seeing open source data or open source engines being utilized to work in an AI workflow, the first thing you need to realize is some of these are going to be under GPL, General Public License. These could be MIT licenses. GPL licenses, what happens is if there are any improvements made when these engines or data sources are provided in an AI algorithm, an AI workflow to generate some output, and tweaks are made to that software, tweaks are made to that data source, under GPL, that goes right back to the community. So if you're valuing a company that is utilizing only open source data and algorithms, the AI engine, there's a lot of trouble there. Because guess what? That small company, IBM, Google, they don't own it. It goes right back to the copyright holder, the author of that data or the AI engine. When you're looking at proprietary, again, no problems. MIT licenses are very favorable for this type of open source utilization of data and the algorithms. When you're utilizing, for example, an LLM, ChatGPT, if that is all licensed and proprietary or done under MIT licenses, any improvements any training, any models that are implemented using underlying data sets that are utilizing the MIT licenses or something proprietary, those are owned by the small company, and therefore the value of that. They own that IP related to it, and in my humble opinion, enhances the value of those companies. Looking at the AI engine, I don't want to get too much. It's just a lot of technical mumbo jumbo, but LLMs are probably the most popular type of AI that's utilized right now. For the past 15, 20 years, these have been convolutional neural networks. A lot of people say just nets. Generative adversarial networks, again, is a more recent version of these types of nets. And you get into the different types of computer vision. This would be a type of algorithm that looks at an X-ray to detect cancer, better than a radiologist is the example that was used previously. Natural language processing, NLP. These are algorithms that would look at maybe a doctor's, a physician's handwritten notes on a patient's history, and they would interpret that with these algorithms to predict what is occurring in this patient. So combinations of these LLMs, neural networks, computer vision, natural language processing, these are the engines, these combinations of algorithms that utilize this underlying data, whether it's proprietary or open source, to generate the final reports, the outputs. So as you can see here, there are a lot of ways to skin this cat. What is typically protectable in intellectual property, where there's patent, trademark, copyright, what have you, it's looking at the underlying, call it prediction. Can you score something better than a human mind would? So in the example, can you take an X-ray and determine whether a mammogram would have an anomaly in the X-ray? And can this algorithm predict whether there is cancer in that X-ray? Well, the better small companies are very highly valued and getting bought out right now by these radiology practices, by hospital systems. And I just happen to be an executive in a company that has gone commercial in this way. The scoring, ranking, classification, recommending things, creating these virtual reality environments, this is all done by AI. And where the IP comes in is where you're protecting. I'm trying to get to the next slide. Oh boy, there we go. How you're protecting the ultimate output of these AI algorithms. All right, you guys, this is where it gets really fun. This is where value comes in. This is where, from a purely legal perspective, you're shoehorning this AI workflow and the final reports that are generated. You want to get these into what we know as the law, copyright laws, trade secret laws, know-how as an adjunct to trade secret. So the input IP is copyrighted. The data, just like a phone book, has a very thin copyright associated with it, but this is data that is utilized as inputs, and combinations of data sets that are copyrighted are going into these engines and creating these final reports. Now, that's problematic. You've heard the stories about OpenAI, the founder of ChatGPT, utilizing copyrighted data sets to train their models and generate all of these LLMs, generate systems for clients to pay a lot of money to generate output, generate a new resume. How do you put something in front of an employer that gets chosen or not? Trade secrets are another way to protect this. If you're training a model, an engine, on how to generate a final report, how you do that is a trade secret. That is something that is written down, that is done confidentially, and if it has independent business value, it is protected by federal and state trade secrets laws. Same with know-how. The only difference between trade secret and know-how is know-how you can't write down. This is something often called show-how. It is protectable, valuable, licensable, royalty-generating intellectual property that protects these inputs. So typically you see this in these vehicles, the in-licenses, the data use agreements. And you guys, I put a bright green dollar symbol next to the aggregated data. This is what's really important about AI. You're training using existing data. But then when you're utilizing the trained model with end users, you're getting their new data. Once you combine the old data and new data and aggregate that into a database, that database, number one, becomes proprietary. Number two, becomes very valuable. My hunch is 90% of our clients, and it's probably 100 clients in the AI space right now, half of their value is based on their aggregated data. This is something that is in-house proprietary to those companies, and they can sell it, they can independently license it. Investors look at that as a vehicle to invest in these small startup companies typically. But that is one of the most valuable aspects, the aggregated data, the old data that you train on, plus new data as you're utilizing these artificial intelligence engines to generate reports for those end users. When it comes down to healthcare, that X-ray looking for cancer, that can do it better than a radiologist, you're looking at IRBs, institutional review boards, and consents from patients. You guys, this is HIPAA controlled, in addition GDPR controlled in Europe. These are personally identifiable information, PII, and protected health information, PHI. These are protected data, and if our clients screw that up, there's massive liability there. Next is the engines. The way that these things are protected is you're looking at new algorithms. These are the proprietary engines that our clients are coming up with, but also ways of modified training of these engines using less energy than Meta and Google and OpenAI are using right now. The entire energy system of the United States will not support AI training the way that OpenAI, for example, trained its ChatGPT systems. Nobody can afford that. Our electricity grid will not support that. So modified training of these engines is a way that our clients are going after AI. That is something completely protectable. And of course, the combinations of the engines, of course. If it's novel and non-obvious, then that is the way we're protecting things. But this will come up, David. I know that we had a kind of an early question on this. The most valuable way to protect the output, which is novel and non-obvious and enabled version of providing a predictive score on whether that X-ray has cancer in it. That is almost always protected by patent, but as I provide here in this kind of patentable system, which is detectable, what we try to do, and this is kind of a kicker here, if treaties are being weakened, and the patent cooperation treaty, which really provides a placeholder for inventors to protect their inventions worldwide with patent application filings, if those are becoming weakened, then we're going to really emphasize our longstanding advice to only patent what is detectable. So you have this neural network or generative adversarial network or LLM, the engine. You have that engine creating an output which is novel and unobvious. Great, you can detect the infringement of that. The training of these models, these engines, utilizing the data, that's your trade secret. Keep the training trade secret. Keep the exact model, the modeling, the analysis, the way you're combining engines whether it's these visual or language learning processes, that's all trade secret. That's know-how. Separately valuable, but that shouldn't go into your patent application, especially if the international patent system is being weakened right now, if we're not enforcing or not recognizing these international treaties like we did just last week. The other way that we look at protecting IP, and here's the value proposition. You have trademarks. Some of them are common law. Some of them are federal registered or independent country registered trademarks. But that really leads into branding. This is the second most valuable thing in most of our clients. The branding is essentially an intangible asset. It is goodwill associated with the way that you sell, your reputation, the way that your reputation provides a basis for good service, a good product. Those are typically enforced by the Lanham Act. And this is something akin to unfair business competition at the state level. That is very valuable. The brand associated with providing these final reports, the scoring of these x-rays, the generation of a resume, things like that. The better you do it, the better your brand is. And that's very valuable IP, and that typically is enforced by the Lanham Act. Vehicles, of course, these are typically the exits. You either out-license it, you get another investment to further develop the technology, or you sell. Okay, I'm going to skip through this because this is really not perfectly appropriate for the legal analysis, but let me just repeat a few things. I just want to kind of restate what I said about the legal aspects of AI and IP and how you protect IP related to AI. Look at it in the business workflow. This is critical. So at the early stage, you're looking at an innovator talking with some kind of a contract researcher, whether it be that the example before was the computer data scientist in Romania. These innovators are talking to the Romanian data scientist before a patent application has been filed, before a trademark has been registered, before anything has been reduced to a tangible medium of expression to copyright it, to get that automatic copyright under the Berne Convention. When you start formalizing the IP creation, the patent, the trademark, et cetera, as we just saw, this is really where the value starts to stick. But we need to really emphasize with all of our clients that you have to look downstream from the IP creation, predict how you're going to get to market, predict the most commercially valuable aspects of your technology, and then protect each evolving aspect of that technology. When we're looking at licensing, we're looking at freedom to operate. We're looking at the validity of your competition's patents, the validity or the picket fence that they're putting around their branding strategy. How close can our clients get to the competitor without burning themselves? So if you're going to be looking at protecting intellectual property, you're always looking at the extent to which the competitor can validly protect their patent, their brand, their trademark, their copyright, and then our clients want to go right up to that. If this FTO, the freedom to operate analysis, has not been done, that's a big red flag. If it has been done, huge value. You always want to look at what is overinvested and underinvested in view of the investors. You want to patent and protect what is underinvested. This is the blue space where our clients typically go. And that is gleaned from discussing this with investors. When you're looking at regulatory, we often, as a firm, Torrey Pines Law Group, works with the FDA, USDA. When we're looking at life sciences and healthcare clients and technology, you've got to get these things cleared and approved, or at least prove equivalence with existing technologies, the competitors. at the government level, whether that's state, county, city, federal. It's a patchwork, and it is very difficult when you're involved in these international regulatory regimes, European Medicines Agency, CE. This is something that we look at daily. If this has not been carefully reviewed, we typically, in due diligence and looking at these issues, suggest that the value is low if pathways through regulatory haven't been identified, high if they have been identified. Finally, if you're looking at the way that the technology is going to evolve, this is the life cycle management. As you're going through regulatory, you're looking at what is underinvested and tweaking your technology and improving your technology. Over time, you're going to follow on with additional patent applications, follow on with additional trademarks, new branding, new copyrights based on these improvements. These are all value add. And in addition, when you are implementing these improvements in commerce, you're actually making sales on these improvements, you're looking at problems, the vigilance. Are we hurting patients if this is a healthcare or some kind of a therapeutic artificial intelligence? Are we hurting people? And then there is a personal injury litigation possibility. Things like that. You always need to look at that, which always informs IP and the way that it evolves over time. So looking at this just as a whole, you want to make sure that when you're protecting IP, and this is what we always counsel clients to do, sure, you look at the innovation and you protect that with a patent. You protect that with a trademark. You protect that with trade secrets. Understood. But as it evolves and as you're looking downstream, that all informs the upstream intellectual property protection strategy, and it involves everything that is found downstream. So I just want to thank you. I'm sure there's going to be some good questions. Hopefully I anticipated a lot of those, David.
Yeah.
But yeah, I just appreciate this opportunity.
Sure. Well, thank you for the excellent presentation. We do have some questions. Just basically, can the real value of AI be successfully patented? Some patent offices don't like to patent software. And then, do you really want to disclose your secret sauce? And even if you do, can a competitor fairly easily design around some code, just
Mhm.
change the coding a little bit and, therefore not infringe the claims?
Yeah. So the first part is so long as there is a technical solution to a technical problem, and you guys, that is the European standard for getting a patent. So long as it's novel and unobvious, and technical solution to a technical problem really relates to enablement in the United States. So if you can show how this thing works in a technical level in a patent application, you can get a patent on it pretty much anywhere in the world. So you claim this as a system, a combination of the hardware and software. And when you do that, you have a very high chance of getting a patent worldwide. Where you're not really going to get a patent is if you just have method of use claims. Sometimes you're not going to get a patent in India. Sometimes you're not going to get a patent on that in some countries that aren't part of the original Commonwealth. So outside of the British Empire, for example, the original British Empire. But then the countries that really love AI and claiming systems, United States, Europe, and Israel. These three sets of jurisdictions really are super advanced in granting very good claims, defensible claims, and that's where a lot of our clients do business. And then what was the other question so far as trade secret and keeping things in a patent
Well,
application?
maybe the ability to design around, or do you really want to
Yeah,
disclose your secret
yeah,
sauce?
yeah. So what I really try to get to is if it's a detectable part of the AI workflow, patent that. Patent what is detectable. If you're able to detect somebody else infringing your patent, sue them. And that's what a patent's for. You threaten suit and get a license, threaten suit and get a sale. That is a valid strategy that a lot of our clients use. But the trade secret, something that is not detectable, something you do not want to put in a patent application if you can avoid it, is the trade secret. What are the data set or data sets that are combined to train that AI algorithm, whether it's a neural network, whether it's an LLM from ChatGPT? Those are the kinds of things you want to keep trade secret. The way that you keep a trade secret is by contract. You have confidentiality provisions in your contracts with your independent contractors, your advisors, your employees. You want to make sure that these confidentiality provisions are provided in there. And so long as the underlying trade secret has independent business value, that's a trade secret that's protectable under state, fed, county, city laws sometimes.
Okay. So the AI that is protected as a trade secret, you mentioned protecting that contractually. Are there other like physical things you should do to protect the trade secrets? Are sometimes the trade secrets of the data set, are they put in escrow accounts? Or, do you recommend that there be a lot of biometrics on the computers that are used to access this, or even putting the computers that house this data in clean rooms that are siphoned off and there's limited access to those rooms?
Yeah. So yeah, from a technical level, this is typically done at Amazon Web Services, AWS, or Azure, or some kind of a cloud computing, cloud data source. So this can be problematic. AWS can be hacked. AWS is typically hacked by people that are harvesting crypto. They'll get into somebody's username and password. They won't care about the data that is residing in the cloud. They just want the resources to mine crypto. But you guys, that's a breach still. And if your data is housed in AWS in Europe, more problems with GDPR and the various country and other jurisdictional laws and regulations if you get breached in Europe. If you keep this in the United States, whether you're safer or not, you have more certainty with the laws and regulations that you'll get sued upon. And this is tough. I'm going to say this I just need to be careful. If there are cloud services that have data centers in China, be careful. That's about all I can say with that. Be smart about it. AWS can have sandboxed data in the United States only without China having access to that data. But sometimes AWS can have access by Chinese sources and other sources that you should think about controlling. All of this is done contractually with a BAA, a business associate agreement with AWS or Azure. There are vendors that help with the security. There are vendors that can be intermediaries. If there is PII or PHI associated with that data, maybe you want that de-identified before it goes to AWS or Azure. So David, the answer to the question is very technical, but you're protecting yourself based on technology first, and then contracts second, and then the laws third. You want to be really smart about working with the technology first on that.
Mm-hmm. Just back to patenting for a minute. Do you find that most AI inventions are patented or not? So if you're an entrepreneur starting a business, you have an idea for an AI product. Let's just say it's AI to predict what presents you should buy for people.
Yep.
Is it likely that I'll get a good freedom of operation report, if I pursue that? Or is it just a waste of time because people don't patent their inventions in AI anyway, and I wouldn't learn anything by doing a freedom of operation report?
Let me add a wrinkle to this. When you file a patent application and you want it to go and have the availability internationally, the patent application publishes in 18 months. Okay. When did ChatGPT initiate? That was about 2 years ago. People have been filing patent applications for the last 2 years using LLMs, ChatGPT. They've been filing patent applications for 2 years. 18 months of those 2 years is a black hole. We have no idea what a competitor has filed on using an LLM, using machine learning, using deep learning, whatever it is. So we cannot do FTO, freedom to operate analyses, because it's a black hole. We don't know what your competitor has tried to patent.
Right.
Once these things do publish as patent applications, are you novel and non-obvious over that? Well, here's the dirty secret as a patent attorney. I can get you a granted patent claim on the narrowest of inventions. It will be novel and non-obvious over whatever anybody else has done. But here's the real trick. Even if you don't patent your technology, call it a trade secret the way that you train a model, the data you're using to train that model, the combination of NLP, neural networks, computer vision. If you keep that trade secret and you're the first mover in developing a present generating prediction model and generating reports on what presents you should buy this particular individual, if you're the first mover, great. It's all trade secret. Forget about the patent. You've got something valuable. You'll make money. DeepMind by Google will outcompete you in about 6 months, but at least you've got a 6-month runway. If you don't get a patent application on that, you're just gone after 6 months. If you do get a patent application and you ultimately get a granted patent, DeepMind has, the 800-pound gorilla has developed its own system to compete with you. Let's say in 4 years when you get a granted patent and DeepMind by Google is infringing, what do? Cease and desist. Google, buy me out, give me a royalty, or invest in my technology so that we can work together as collaborators. You're going to make money even if DeepMind starts interfering with your commercial model. The thing is, to utilize that model, you have to have a patent application pending, and you have to have a granted patent ultimately to force DeepMind's hand.
Okay. So another question, you were talking about the difference between proprietary data sets and open source, codes and stuff. In developing a new AI, can you use some of both? Can you use some proprietary sources and open AI? Just have to make sure you don't commingle.
Yeah, so from a technical level, sometimes you want to avoid commingling. You want to use the proprietary known data to train the model so that when new data comes in, you can make sure that it's working adequately. But you guys, this is critical. This is one of the most valuable parts of any startup company all the way to Google. Aggregated data. The aggregated data is old stuff plus new stuff. That is in my opinion, that is half the value of most of our AI clients. When you're commingling the old data and new data and improving the training of the model so that better predictive reports, better scoring, better triage, better ranking reports can come out. That is the final product. That's what you're selling. So when you're aggregating the data and improving the model training and improving the output, that is so critical to everybody on this call. That is what's highly valuable. That is half the value of most of our clients, in my opinion.
But you have to be careful if you're improving things using open source, because the improvements can be used by everybody on open source.
So that's mostly with respect to the engines. So the typical example is MATLAB. So MATLAB is and actually C3 AI is another source of these open source engines. These are the neural networks. And it's just computer code. So unlike data, which is just, again, something you can tabulate, this is source code. So if a company is being valued and they have amended the source code, improved the source code, the neural network, the machine learning, the deep learning, the generative adversarial network, if it's under a GPL license, and I think it's GPL 2.0, the improvements go back to the community.
Mhm.
I mean, in my humble opinion, that engine now has zero value. If our client is utilizing open source and modifying the open source software that doesn't belong to them, my dear Lord, how do you even patent that?
Yeah.
If it's proprietary, that is owned by that company. It doesn't go back to the community. That is what is trade secret. That, if you wanted to publish that, that is something you can patent. Good luck detecting the use of it. That's why we typically don't recommend patenting source code. And as you mentioned, David, software patents, they're frowned upon in most jurisdictions nowadays. But if you're claiming a system, a combination of hardware and software, that novel algorithm, and generating novel output and non-obvious output, that's pretty critical. That could be something highly valuable and definitely patentable if it's novel and non-obvious.
Okay. Just maybe two more questions. One is anything you want to say about cleaning of data? You talk a lot
Yeah.
about data. Just a couple of weeks ago, we had the story of the young woman who sold her company, Frank, to
Yeah.
JP Morgan for 175 million. And she represented that there were 4 million accounts and there were only 300,000 accounts of college kids looking up applications. And she had a professor just kind of generate a bunch of data, a bunch of accounts.
Yeah.
Um, so anything you want to say about the cleanliness of data or steps that AI companies
Yeah.
should do to make sure their data is clean?
Aside from the stupidity of committing fraud, uh, our clients are typically in very highly regulated markets. Uh, cleaning of data, I call de-identification.
Oh,
So when you are looking at underlying data, so I used to be a lawyer for a big research foundation, looking at a lot of very highly sensitive data, people's medical records. We want to make sure that privacy is protected, that the safety of the individual subject, the patient, in some cases, is highly protected. So typically the data sources, when it becomes very sensitive, Europe is very sensitive about this. The de-identification of the data occurs at the source of the data. Where our clients sometimes come in is they will have a layer on top of that source of highly personal, very sensitive data, and they will scrub it before it goes up to AWS or Azure or other cloud-based system. And then typically what happens is when the de-identified data goes up to the cloud and then back down to the client server, the algorithm typically resides up here in the cloud. When this goes up to the cloud, you can scrub it here or scrub it here. Typically, it's at the source, a university, hospital system, IBM, Google, Facebook. They have very highly sensitive data sets that they will de-identify before it goes to AWS, and certainly before it goes down to the client server. Here's where the liability occurs. The BAA, the Business Associate Agreement between the client and AWS, that protects you from a legal aspect pretty well. If you have that BAA in place, that's, get it in place, guys, if you don't have that. De-identification between the source of the data and the cloud, you either have the source of the data, de-identify the data, you have some kind of a software that scrubs the data, or you have some vendor between AWS or Azure and that original data source to scrub it for you. You have to do this at a technical level. There are all kinds of agreements, indemnities, limitations of liability, hold harmless. That is what you need in place to de-identify the data. Don't commit fraud, guys. I guess that's an answer to the question.
Okay.
look at it from a technical level first.
Okay. And then the last question, you mentioned that something happened at the PCT last week in the era of all these tariff disputes.
Yeah,
What happened?
this is so challenging, guys. Well, what happened is the US federal government is looking at things differently than I think a lot of us IP guys expected. So, reciprocity, there's a lot of words out there right now, but reciprocal tariffs is, those are two words that mean something. Reciprocity is something that, as an IP lawyer, and I've been doing this for 27 years, that's really important to me. It's really important to my clients in protecting things internationally. If reciprocity under treaties is going to be treated differently now, then I always look as an IP attorney, a patent attorney, at the Patent Cooperation Treaty. It's a treaty. It's all based on reciprocity. If China is not going to be enforcing US patent rights, or if China is saying, hey, you guys, we're going to do compulsory licenses. If we've got an emergency in China or the Philippines or India, and this actually happened in India with Gleevec, if this is a health concern in India, you guys, you citizens of India, you pharmaceutical companies in India, you don't have to get a license to Novartis's drugs. Just mass produce them. We need to protect our Indian citizens from breast cancer, from any kind of disease using patented therapeutics. Well, what if, based on lack of reciprocity, China just says, you know what? We're all these things disclosed in US patent applications going into China through the PCT, through the Patent Cooperation Treaty. What if China says, utilize them, guys, compulsory license? I don't know what US is doing. We China citizens, we need some freedom to operate. We're not going to enforce US patents or patents of US companies coming into China. That's all about reciprocity. I'm thinking about this differently. I'm thinking about how our clients disclose their inventions in patent applications going into China, as well as Europe. And you guys, I think this is a very serious consideration for everybody. And here's my opinion. This is my personal opinion. This is the advice I'm giving to clients. Keep more things trade secret. In your patent applications, you know it's going to publish. You know European competitors, Chinese competitors. Even if you have a patent application pending in those jurisdictions, be careful with what you publish. If you're publishing your secret sauce, put alternative embodiments in. If there are compulsory licenses by China and Europe to use your invention without paying you a royalty, at least breadcrumb it. Make somebody work relatively hard to find out what your real invention is, what the commercial embodiment, what the AI algo is that's producing this predictive product. Be careful of what you're disclosing so that you don't get a compulsory license slapped on you in a foreign jurisdiction. That's what changed last week with this reciprocal aspect of what we're doing as a government. I don't know what we're doing. I don't know how Europe and China and all of our other competitor nations are doing with that information. I'm just being more careful in what I disclose in patent applications.
But was there an instance of mandatory licensing or
No instance. Yeah, I'm predicting myself. Sometimes I've got a pretty good nose for this. I'm predicting that some of the reaction to what we're doing with reciprocal tariffs, I'm predicting that there's going to have other manifestations with other laws, including intellectual property laws, in reaction to what we're doing reciprocally. I'm all looking at reciprocity and the interplay with how we are challenging other nations right now. With tariffs, I think there could be a reaction with respect to IP.
Mm-hmm. Yeah, just one point along with that is patents owned by by foreign companies. Their U.S. patents could be more valuable because if their products are excluded from the U.S. markets because of tariffs are too high,
Yeah,
then the only way they can commercialize is by licensing their patents in the U.S. or asserting their patents in the U.S.
yeah.
So
Or here's the kicker, and this is already happening with federal grants. There's a requirement to actually manufacture this stuff in the United States. So a lot of countries have these mandatory manufacture. If you get a patent in India, they want to see that you're manufacturing the good or service or whatever it is, whatever you're patenting, that you're utilizing it and making people in India make money with whatever is being patented in India. That's been the case since I think 2005, the Patent Law Act of 2005. The United States can implement something just like that. It's all about protectionism, and I agree with this wholeheartedly. If China is going to come in and patent things in the United States, not only can they enforce it here, but the federal government could establish a new requirement to have this Chinese company or European company establish manufacturing of whatever is patented in the United States. That is a real possibility. If we're becoming more protectionist, that's a real possibility of being required when you're patenting from a foreign jurisdiction in the United States.
just the last question, this is a little bit off the track, but so in India, is it a requirement to have some evidence of your intent
Mhm.
to manufacture in order to get a patent?
You bet. I think it's 3 years, we get a form from a variety of different Indian patent law firms saying, prove that you're manufacturing this therapeutic in India. Shows data, shows something real that we can take to the Indian government. Yeah, that's a requirement in India right now. It has been for a long time. I can see that being implemented if everybody's becoming more protectionist worldwide. I can see that being a requirement for pretty much every country.
Okay. Well, I think we can end this session here. I'd like to thank Kevin Buckley from Torrey Pines Law Group for speaking to us today. This was an excellent session. He did a great job of educating us on the intersection of intellectual property law and AI. We very much appreciate that. Appreciate all the answers to all of our questions. So I'll end the session here. We ran right into this session. I didn't have time to 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 mention who the new winners of this book are. I mentioned before that we are giving away 5 copies of this book, Business Model Validation, which could be of interest to people that are trying to discern AI business models. So the two people, additional people that will get the book are Quentin Barand from Wintix and Timothy Menard from lyt.ai. All right. So great. I made my comments a little bit earlier about 10:30 this morning Pacific, so we're done with that session. So I think we can conclude the conference. We really appreciate everybody attending and asking all these questions. And I think the session today was very informative. The first speaker gave us a lot of insight into AI scaling laws. That was pretty intense. There was a little bit of math in that session, but very interesting. We had a great panel of venture capitalists talking to us about what elements of companies they like to see when they're considering investing in AI companies. And I gave my comments and provided a little bit of concern, a little bit of skepticism for some of the very aggressive valuations that we're seeing for AI companies. Not everybody's going to be a winner. Kevin, you have a background in some math, I suppose. So I think it's true to say that 90% of companies cannot be in the top 10%. Right? So, not all these companies are going to be winners, unfortunately. So I did want to share that concern with you. And then last couple of hours, we had great sessions on the intersection of employment law and AI, and then intellectual property AI. So thank you all very much for joining us. Please check back on our website, davosinthedesert.us, for upcoming programs. We like to see you at other events, and feel free to keep track of our activities through our website. Thank you.
Thanks, David.
Yeah, thank you. Very nice session, Kevin. Really appreciate it.
Yeah, it was cool. Yeah, I just appreciate, you know what, being in this group, David. Yeah, I really appreciate your getting me involved, because this is huge for a lot of our clients, and we do a lot of due diligence, and we're just trying to steer people toward people like you.
I appreciate that. Yeah, I appreciate that. We'll send you the video of your session so you can use it how you see fit. You can put it on your website or use it in social media. We'll make it available too, and get some traffic to that. So I hope it helps you. And yeah, feel free to call me if you need some valuation work done.
We always do, and yeah, I'm so happy you reached out, and we've got to get our people to you, because for whatever reason, nobody exists in San Diego that does what you do, David. So yeah, we'll definitely send people your way.
That sounds great. Thank you again, Kevin. Take care.
All right. Take care.
All right. Goodbye.